Welcome to Sable International's webinar series on obtaining UK nationality through former colonies or territories. Today, we'll be discussing links via New Zealand. Just a little bit of housekeeping before we begin. We will have a Q&A at the end of the presentation. If you look on the top right-hand side of your screen, you will see a chat box function. If you have any questions, please post your questions on there. What I would like to ask is that you post your question in the format that I've just pasted in that chat, where you can put your name, your place and date of birth, your parents and your grandparents' places of birth. And if you can put all the information in one go before hitting enter or send, so that all the information is put together, which makes it easier for us to answer those questions. We also have a poll, which will be live, and it'll be interesting to see what the closest links are to the UK. There's also a you can adjust the presenter panel. You can make it larger or smaller with the plus or minus button on the top right hand side of your screen. If you'd like to make the presentation full screen to see it better, there are arrows that are pointing away from each other. If you click on that, you can maximize and minimize your screen. With the Q&A, we will try to get to everybody's question. We do normally have large numbers of questions, so if we aren't able to get to everybody's question, don't worry. We will send a recording of this webinar to you, and you can contact us on one of our many channels and ask us the questions or complete our assessment, as we will ask you to do a little bit later. A little bit about Sable International, for those of you that don't know. We have been in operation since 1995. We have offices in the UK, 2 in South Africa, an office in Australia, and we have a presence in Portugal. We have 6 core services that we specialize in, which we believe that these services encompass vital aspects of our clients' needs that they have when investing offshore or moving abroad. Those are citizenship and immigration, wealth management, accounting, personal and business, tax advice, cross-border tax assistance, foreign exchange, and then residency by investment as well. Your presenters for today, my name is John Dunn. I'm the Sales Director of the Citizenship and Immigration Division of Sable International. We have Philip Gamble. Philip is a founder and senior partner at Sable. He trained with the Home Office within the Citizenship Directorate until 1992 and is widely regarded as the foremost authority in the world on British nationality law. We also have Michelle Patel. Michelle was born in Mombasa in Kenya, and he relocated to the UK in 2004. Michelle joined Sable International in 2009 and is registered with the OISC. Michelle specializes in isolating claims to British nationality for those who have connections to former British territories. So without further ado, I'm going to hand you over to our presenters, Phil and Michelle, to start the presentation.
Okay, good morning from London. As you heard, my name's Philip Gamble, and I head our citizenship division down here in London. And we're going to talk to you today about how you claim British nationality by connection, specifically with New Zealand, but with other British territories as well. So to start off with a bit of background information on how this type of thing works. So when we look at a particular case, we'll look at your family tree, not for genealogical purposes, but to effectively look at the law that was in place at certain key points in the past. So those key points might be the birth of an ancestor, the place of birth of an ancestor, date of marriage for parents, or indeed where your family members lived in the past. There's different legislation in force at different times, so different forms of British nationality are acquired through birth and by descent in different territories. There's actually 5 different forms of British nationality available that are in common usage. At the moment, slightly more with some of the minor ones, and it's not uncommon for people to have more than one form of nationality at the same time. And as you'll see from the first slide that's up here, we've listed a few of the key dates for you, particularly with New Zealand as a territory itself. So you can see up until the 31st of December 48, bringing us almost into the modern day. New Zealand has the status of being within the Crown's dominions. It's a self-governing territory within the British Empire at that point, and at that point you're looking at specific statuses being granted by birth, particularly British subject status, as you'll see in the next slides. From the 1st of January 1949, this is when our British Nationality Act 1948 comes into force. New Zealand citizenship is born, so New Zealand still remains a self-governing territory within the British Empire, but it has its own form of nationality at that stage, and where British nationality effectively ends. 1st of January 1983, our modern day British Nationality Act comes into force, and this has been modified many times since that point. Okay, so we're looking specifically at the status of your ancestors at the time they were born, which forms of British nationality they acquired, whether those passed by descent, and then lastly, whether the legislation of New Zealand or later legislation in the UK has had any effect of taking any status gained for the ancestors away. Any residual statuses can be brought forward to the modern day, and usually passports issued. Okay, so moving on, and again, just before we start, some countries prohibit dual nationality. That's the holding of two citizenships at the same time. As you can see from the slide here, the UK, New Zealand, and Ireland all allow dual nationality. So if you are able to claim British nationality being a New Zealander, this will have no effect on your existing New Zealand nationality, and you can hold two passports at the same time without any problems at all. So we're lucky in that respect, and New Zealand becomes effectively a good place for holding multiple passports. Right, so on to the mechanics and how one actually acquires status. So you can see here we've got the most obvious way in which someone can acquire British nationality, and that's by birth. So we mentioned on the first slide that New Zealand effectively has its own form of nationality and citizenship from the 1st of January 1949. Birth in New Zealand before that time gave rise to a status called British subject status, because there's a common form of British nationality across all empire territories, being effectively British subject status or British nationality in general, if you prefer. It passes one generation by descent. However, those connected to New Zealand generally lose this status on the 1st of January 49. So birth in New Zealand alone isn't going to give you a claim to British nationality in the modern day, either whether it's you or whether it's one of your parents. So going on from there, it becomes clear that if you want to claim British nationality, you can only do so if you have an ancestral connection with another territory outside of New Zealand. This doesn't necessarily have to be the UK. It could be another place which remained under full control of the UK after 1949, like Kenya. So there's a difference here between places which are colonies, if you like, in the post-49 period, and those that are self-governing dominions within the empire, like Australia and New Zealand. So a person born in New Zealand whose father was born in the Kenya colony, or perhaps grandparents were born in the UK, has a shot at getting British nationality now, but a person who is a third generation New Zealander, as in you born in New Zealand, your parents born there, and your grandparents born there, is unlikely to have a claim. Okay, so that's how it works in terms of birth in relation to New Zealand directly. In terms of citizenship by birth in general, the next slide starts giving us a few details here. So this is specifically about birth in the UK at this particular point. So as you can see here, if you're born in the UK before the 1st of January 1983, you're likely to have a claim to British nationality. The only exception was where effectively parents are foreign ambassadors or any other diplomats, or in the military of another country, so they're exempt from the laws of the UK at the time. Otherwise, all people born in the UK will become British if born there before the 1st of January 1983. I should say that at that point, British citizenship didn't exist. It was called citizenship of the UK and colonies. So it was a slightly different status which has evolved over the years. If you're born in the UK after the 1st of January 1983, or on or after, I should say, you'll find that the acquisition of British citizenship is no longer automatic. So whereas in the pre-83 period, you generally get citizenship by birth, whatever, when you're born after that time, then one of the parents must be British or having a status of a permanent resident at the time. So birth in the country on its own after 1983 is no longer sufficient. You need to have another connection with the UK as well by having a parent born there, perhaps, and holding British citizenship, or the parents holding the status of a permanent resident. This is quite common with other countries across the world now. Most countries in the past simply gave citizenship by birth. In most European countries now, and indeed New Zealand and Australia, it's again similar, citizenship by birth. It's not automatic these days. You have to have a connection with the country as well. Okay, the next most obvious area is, of course, citizenship by descent. So in this case, we're looking at the first generation by descent. So we put here on this slide applicant born outside of the UK, or specifically New Zealand, if you prefer, for the purposes of this seminar. Father born in the UK and mother born in the UK, so either parent being born in the UK. So we've got two anomalies here which kick in, and the first is that up until very recently, a child born out of wedlock, or an illegitimate child if you prefer, could not claim British nationality by descent from the father. The parents always had to be married, and before the 1st of January 1983, British nationality only passed in the male line and not in the female line. So if your mother was born in the UK and you're born before 1983, originally there was no claim to UK citizenship. Now, not surprisingly, the UK government has updated itself over the years. Now it's possible for either the father or mother to pass nationality, whether the parents are married or not. And again, this is in common with most countries around the world. As a remedy for people who were born in the days when they were disadvantaged, the UK allows a specific application to be made now, which will allow those people to gain British nationality. So if you missed out because your mother was born in the UK and you couldn't claim citizenship originally, there's now a remedy through a specific application that can be made, which we call registration. And the same applies to those who couldn't make claims through their father's line because their parents weren't married originally. So two specific types of application, which are now possible, which weren't possible in the past. Okay, going on from there, we start getting into more interesting territory because we move on to the areas where you can claim British nationality in the second generation by descent. So with these types of claim, generally some other criteria apply, and we've got a number of slides here which show some of the positions available for second generation claims. On this one, it's specifically about Crown service. So the law defines Crown service in a specific way, and with New Zealand, one of the ways in which it's defined, it's called designated service apply. So this applies where the grandfather, either on the mother's side or the father's side, would be born in the UK. The father or the mother, depending on which line of the family we're coming through, must be born in New Zealand before the 11th of June 1943. And the applicant themselves, the person claiming, yourself perhaps, has to be born after the 1st of January 1982. So what this slide is effectively showing is that where a grandfather originating from the UK is with perhaps the civil service and then moves out to New Zealand as part of the New Zealand government at the time, it's possible for a claim in the second generation by descent to come in for the grandchildren of that person in Crown or designated service. You'll see the specific date of the 11th of June 1943, and this is actually the date when the UK ceases to be in control of foreign affairs for New Zealand. So for these designated service claims to exist, the UK has to be responsible for the external or foreign affairs of that country at the time of birth of the parent, and that stops in 1943 with New Zealand. As you can see, the recruitment for the Crown Service in question must also have taken place in the UK. So that's your first variety of citizenship by double descent, or citizenship in the second generation by descent. The next slide moves on to another variety of citizenship by double descent. This relates to the laws that were put in force to effectively give the remedy against gender discrimination in the earlier law. So what you can see here is that the paternal grandfathers born in the UK. We know that citizenship always passes in the first generation by descent, so we know that the father also acquires British nationality. What's less well known is that those who were married before, or women that were married before 1949, 1st of January, automatically acquired the citizenship of their husband. So in this case, with the father acquiring citizenship by descent from his father, the mother acquires British nationality through marriage. Now, when the laws were put in force to address the gender discrimination, it was not seen at the time that women could have acquired citizenship through marriage. It was something that was perhaps overlooked. And because of that, there was no stop put on the ability for it to pass a further generation. So women who acquired citizenship through marriage were never classified as what we call citizens by descent, and therefore unable to pass the nationality to a further generation. So because of that effect, and the mother acquiring citizenship through marriage, then the applicant in the modern day, if born between 49 and 1982 in New Zealand, Australia, or indeed any other place in the world, will be able to make a claim to citizenship in the second generation by descent. So you'd be forgiven for thinking that if women acquired citizenship through marriage, that they perhaps lost British nationality if they then divorced their British husbands. British nationality law is never that straightforward. It never follows common sense, and in fact that wasn't the case at all. So a woman who acquires citizenship through marriage keeps it even if the spouse later dies, or perhaps the couple divorce. So that woman could potentially go on to marry another man, so you could have a second husband for that mother. And unbelievably, the descendants of the second marriage, or the issue of the second marriage, are also able to claim. So you get a weird feature coming into play where you can claim citizenship through your mother's first husband, who of course is not your father. So you get odd things where it doesn't follow the complete line of descent in the natural way, and odd features that come into place. So by this stage, you're probably getting an idea of the type of work that we do. We look for unusual claims in British nationality when we're looking at your family trees with a view to isolating those. Okay, so that's enough from me. I'm going to pass you over to my colleague Michelle now, who's going to talk to you about some other ways in which you can qualify. I hope you found that interesting.
Thanks, Will. Thank you. No. So, hi guys. Good evening, probably on your side of the world. I will talk to you. I'll go through the next sort of seven slides. So we'll just jump onto the next one, citizenship by double descent under Section 7. This is actually going on from what Philip was saying about those born before 1983 not being able to claim British nationality through the maternal line. So the UK were quite aware of this gender discrimination, and I think their first attempt to correct that gender discrimination gave rise to this provision on the 19th of Feb 1979, where the Parliament in the UK did pass sort of instructions onto British posts abroad, including their own civil servants in the UK, to allow, those born specifically before 1st January 1983 to UK-born mothers, which is why you see parent and grandmother born UK in this family tree, to allow that parent in specific to be registered as what we call a citizen of United Kingdom and colonies, which was just the former form of British nationality available in the period before 1st of January 1983. But, that was the UK's first attempt to correct that gender discrimination. But what we found is where a parent has been registered through their mother's birth in the UK, specifically under this section, it would have taken place before 1983, and the parent would not necessarily have lived in the UK at that time, could very well be living abroad. But where that parent has been registered in this fashion, that parent would be classified as what we call a British citizen other than by descent, when the rules changed on the 1st of January 1983. So this can be either mum or dad, and the reclassification as a British citizen other than by descent on the 1st of January 1983 would enable that parent to pass on their British nationality a further generation born after that date and out of the UK. So if you are someone that's on this webinar and you are a parent that's looking for citizenship claims for their children, the question here is why are you someone that had a UK-born mother, and why are you someone that was registered as a British national before 1983? If the answer to that is yes, then potentially your children who were born after 1st of January 1983 could have a claim to a British passport through this certain provision. One thing to add there is that this can be through legitimate line as well these days, and the parent would just need to prove that registration more or less. So that is one way which is quite interesting and may apply to some of you on this webinar. To the next slide. So I did see a few people on this webinar, and in particular, I think was someone called Justine. I don't know if you're still on this webinar, Justine, but I saw your comments and I thought this slide could apply to your children potentially. This is citizenship by double descent, section 3 in brackets 2. Now, what this is where you have a parent who, unlike the previous slide, is not classified as a British citizen other than by descent. It's classified as a British citizen by descent, and in most cases, it happens where the parent is the first generation born out of the UK and the relevant grandfather for the child, say, was born in the UK. So this parent is by descent, and under the current rules, most children born to a British citizen by descent out of the UK cannot claim their British nationality through that parent. So there is a provision to combat the ability of that parent to pass on British nationality, but it's a formal registration. And this registration has a certain set of criteria. And one of the few criteria is the child has to be under 18 at the time of the registration. The parent had to be a British citizen by descent at the time this child was born. And the parent themselves would have had to prove that they've lived in the UK at any point before the child's birth for 3 years. Now, in those 3 years, the parent must not have been out for more than 270 days. And the parent's parent, so it could be the mom or the dad, was born in the UK or a British citizen other than by descent. So if you are such a person who's got a child under 18, you yourself have a British passport, i.e. you're the relevant parent, and you got it through, say, your father's birth in the UK, the question is, have you spent 3 years in the UK in the past before the child's birth? And if the answer to that is yes, then potentially these children or your children would have a claim to citizenship by registration as a British citizen under Section 3.2, and that can be done from outside the UK, and the family or the child does not need to be in the UK for that application to be processed. So that's one route for children. Citizenship by marriage, far more straightforward than the previous slide. This is just where specifically a woman has married a British man before the 1st of January 1983. The woman has to have had Commonwealth citizenship throughout that time until present. So it can't be someone that ceased to be a Commonwealth citizen even for a day. So if you are, say, a woman that was born in New Zealand, but you married a man who was, say, born in the UK before, and you married, that marriage happened before the 1st of January 1983, then you could have acquired at the point of your marriage something called the right of abode. Now, the right of abode is basically a status that's still very well alive in the modern day, and it entitles the holder to visa-free access to the UK. So you would not need a visa to come enter the UK, nor would you need a visa to live and work in the UK. If you were to stay on the right to abode for 5 years continuously in the UK, then you could be eligible for a British citizenship through a process called naturalization. So again, we find the right to abode is the next best thing to be a British citizen, and cannot be automatically lost even if you stayed away from the UK for the entire time and never chose to come in. So if you are such a person, then you should let us know in the comments, and we can sort of confirm that in the Q&A at the end of the session. So again, sorry guys, I made a slight mistake. So the right to abode was actually that I've just explained is this slide. I'll just come to the citizenship by marriage. Sorry, what this slide was actually about a woman that's married a man before the 1st of January 1989. And in this instance, she becomes a British citizen at the point of that marriage. And in the modern day, she would have a British passport. Apologies for that oversight. And as I explained, this is the right to abode. Adoption. Adoption is quite a complex part of British nationality law. And with the adoption, if an adoption, of course, happens outside the UK, the chances of that child being given British citizenship are quite slim. So where adoption has happened, say in New Zealand, even if the father was born in the UK, or the adoptive father was born in the UK, or the adoptive parent, I should say, was born in the UK, the child would only have a claim to British citizenship if the child is under 18 at the time we attempt their registration. But if the child has now turned over the age of 18, even though the adoptive parent is a British citizen by birth, unfortunately, no rights of British citizenship would pass on, or any status to this child. If the adoption has obviously happened in the UK, then there are further rights there. I should say that if someone is over 18 and has been adopted by a UK-born parent, you can acquire British something called the right to abode. And with the right to abode, as I explained earlier, gives you visa-free access to live and work and reside in the UK. You would need to be a Commonwealth citizen for that to be available. UK immigration. So this is now coming away from right to abode and British nationality. So with UK immigration, there might be a lot of people on this webinar who may think none of those slides apply to them, but that's fine, because you do have other routes to enter the UK, and through coming into the UK on these routes, you may be entitled to settlement and then naturalization. So I'll just talk you through the sort of four main immigration routes. So we got the first one up there, which is a 2-year working holiday visa. Again, this is only for those aged 18 and 30. So a citizen of New Zealand between this age can come in and work in the UK. You would get a 2-year visa initially to come into the UK. And whilst you're working here, you could attempt to then go into the normal work permit route, which would then entitle you to stay further time in the UK. With the ancestry visa, a lot of comments were made about the ancestry visa and whether your child or am I entitled to ancestry visa. So the main criteria is you've got to be age 17 and plus. The Commonwealth citizen requirement is a must. So you, as in New Zealand, of course, you would meet that, and you've got to have a UK-born grandparent. So this is not a grandparent that was born in a previous British territory. This is a grandparent that's actually born in mainland UK. Includes obviously Northern Ireland as well. You would get a 5-year visa on the ancestral route to come into the UK. Whilst you're completing your 5 years, you can work for anybody in the UK. So you're not entitled to just work for any one employer. And whilst you're here, you can also bring over your family members. So this would be your children under 18, as your dependents, your spouse, and a married partner can also come in. And at the end of the 5 years, you will be given the opportunity to apply for indefinite leave to remain, which is our version of permanent residency, and then look forward to naturalizing a year on from there. Spouse visa. So with the spouse visa, as is probably quite obvious, it's where you're married to a British citizen. If you're unmarried, then you need to prove that you could be cohabiting for 2 years, and you could come over on that visa. You get a 2.5-year visa initially to come over with your British spouse. At the end of that 2.5 years, you would extend that for a further 2.5 years within the UK, taking you up to the 5-year qualifying period ending, at which stage again you have the opportunity to apply for indefinite leave to remain and then naturalize as a British citizen thereafter. Work permit. So this has obviously been a major changes have happened to the work permit scheme, or will happen to the work permit scheme, I should say, from the 1st of January 2021. But overall, the work permit scheme at the moment is called a Tier 2 visa, and that requires a UK employer to sponsor you to come work for them within the UK. Now, again, this will enable you to use your time in the UK under the work permit route to get you up to the 5 years. Again, at that stage, you can apply for indefinite and then qualify for British citizenship thereafter. Points to add about the work permit is that at the moment, it is quite strict, but from the 1st of January 2021, the UK government has promised some changes to make it easier for UK employers to sponsor those from out of the UK. Some of the main changes include the fact that at the moment, a UK employer has to show that they try to recruit locally by advertising the vacancy in 2 relevant places for a certain amount of time. Again, they have to show they've interviewed candidates and have not been able to find the relevant person within the UK or the EU for that matter. And that is called the resident labour market test, and that is no longer a requirement from the 1st of January 2021. So from that date, a UK employer does not have to justify why they're trying to recruit from out of the UK, which makes it a lot more easier for a UK employer to sponsor someone or think about doing so. So again, we feel that it would be much easier for those outside the UK to come into the UK on just being sponsored by a UK employer. So that's your immigration options. Now, coming away from the UK entirely and going into Irish nationality, as Irish citizens are still allowed within the UK even after we leave the EU at the end of the year, because of a special arrangement between us and Ireland. So we thought it would be quite fitting to talk about those with Irish ancestry. So it's far more straightforward than the UK, I believe. So we've got 3 routes. First one by descent, again, quite straightforward, where your parents born in Ireland or Northern Ireland. However, again, your birth has to be legitimate for that to happen. Double descent, much like the former one, you have to have legitimate connection to that Irish-born ancestor. So this can be where grandparents born in Ireland or Northern Ireland, and their subsequent generations are born legitimately. Obviously, we recognize there may be people who do not have Irish-born grandparents or parents, but their parents or grandparents may have gone over to Ireland and naturalized as Irish citizens. Again, that Irish nationality, we believe, can be transmitted multiple generations, where there's been a legitimate birth at each generation. So if you are someone that does not want to apply for any of the British nationality, or you don't have those options, and you have Irish-born grandparents or parents, this might be an easier route for you to enter, live and work in the UK. So that is enough for me. I'll pass it over back to John. Thank you for listening. Thank you.
Thank you, Michelle. Thank you, Phil. That was very interesting. There's a lot of information there. Just a note again, we will make this webinar available to you as a recording. We will email it to you, and it will be available on our website. If you have any questions about the immigration, you can contact our Australian offices. I see our UK numbers up there, but we do have an office in Australia that can assist if the time zones are a bit out. But yeah, so you can speak to somebody, you can get the information on our website, and this will all be made available again after the webinar. So after seeing all that information, there's a lot of questions that have come through, and the main question that everybody has is do I have a claim to British nationality? So we'll go into a little bit more about how we can find out about that. What we will do is, even if we answer some of your questions today, we ask all of our clients to complete an online assessment for us. I have posted a link to that assessment in the chat box. You can go through and click on that and complete it. It is a free assessment. It will ask for basic information similar to what we're asking in the Q&A, information about your parents and your grandparents' place and dates of birth. Once you've completed the assessment, we'll ask you to order what we call a free British passport review. This will allow the specialists to have an overall picture of your family tree, and they will give you one of five, their opinion will come in the form of one of five answers. One, they can see a definite route to citizenship, and we can go straight forward to an application for you. The other is a remote, where we don't see a route to citizenship, and it's not likely that you'll get one, and the road will end there. Then you may get an unclear or an unlikely answer. There is still a chance of British citizenship, but we will need to get more information. And then there is a likely chance of citizenship, which we feel is a very good chance, but either of that likely, unclear, or unlikely, we will then move on to what we call a status trace. If you get a response of unlikely or unclear in your British passport review, there is an option for you to do a phone consultation with our presenter, Michelle Patel. This phone consultation is to get more information for you and move you into one of two, or get you to one of two answers. Remote, we can now see that there's no chance based on the information that you've given us, and we will give you a remote answer, but we will, however, give you options for EU or Irish nationality or visas if there is any available to you. The other answer that you might get from Michelle is that he has now gotten information from you that's moved you into the likely category, where we think there's a very good chance you claiming nationality, and we can then move forward to the trace as well. So what is a status trace? A status trace is where the specialists in the UK will look at your family information and dates of birth and the nationality law applicable at the time, or those times. And that status trace will give you two definitive answers. One, there's no claim to citizenship. You shouldn't continue. But if there are, again, if there are options for EU nationality, Irish nationality, or UK immigration, we will give you that information. Or yes, we can confirm you definitely have a path to citizenship. We'll explain to you why there is a path and what application needs to be made. And then we can, of course, assist you with that application if you choose. So now we'll move on to the Q&A part of the webinar. Like I said, we get quite a lot of questions. We would love to answer all of them. If we don't get to you, our apologies, but you can get in touch with us on, we have a WhatsApp chat function on our website, email, phone. You can complete the online assessment or email us. We're happy to help you in any of those formats. So the first question that we have is from Roger. Roger was born in New Zealand in 1958. His father and mother were born in New Zealand as well. His paternal grandfather was born in the UK, and his paternal grandmother. His question is, does he qualify?
Okay, so I think I'll start that off. I mean, certainly, Roger, we can see immediately that you qualify for the ancestry visa, if nothing else. However, really, the key thing here is when were your parents married? If they were married before 1949, then you've got a good chance of a claim. John, do we know that marriage dates?
Roger hasn't put it. Roger, if you're still on, if you can just post your parents' marriage date, we can possibly get you that answer then.
Okay, well, it doesn't matter. We can do things either way. So effectively, we know that Roger's grandfather is going to have passed citizenship to his father in the first generation by descent. If the parents' marriage had taken place before 49, it would mean that the mother would acquire that citizenship and it would be transferable by descent to Roger.
Sorry,
if it's
Phil,
not,
they were born in 1952.
Okay, so we know that it's a not then, in which case. So under those circumstances, his mother would have had the option to register as a British citizen, because wives were still allowed to claim citizenship if they wanted it, but it wasn't automatic. So on the assumption that no registration took place, I'm afraid this would be an ancestry visa only. So Roger would need to come to the UK, spend 5 years here, working or effectively being economically self-sufficient, and he could then claim the permanent resident status and then naturalise as a British citizen thereafter. But there's no direct claim to citizenship here as far as I can see.
Okay.
Okay, sorry,
you,
Roger,
Phil.
that's the first one.
We'll move on to Pam. Pam was born in New Zealand in 1958. Both parents born in New Zealand were married in 1953. Her maternal grandfather was born in England. And that's the last of the information Pam's provided.
Sorry, John, could you just repeat where Pam, what year Pam was born in, did you say?
1958.
In New Zealand?
Correct.
Yep. And her parents were both born in New Zealand?
Correct.
And it was a maternal grandfather was born in New Zealand, did you say?
That's right.
Yeah.
No, maternal grandfather born in England.
Sorry, in England. Okay. Yeah, that's right. Yeah. Okay. Okay. No other information. Okay, Pam. Yeah, I think we can immediately see that even though your mother would have picked up her father's nationality, he wouldn't really pass on to you, unfortunately, in this instance. The only other time that would be the case would be if your maternal grandfather was in Crown service at the time your mother was born, which is quite rare, but not entirely impossible, I guess. Now, the other thing here, Pam, is of course you would be entitled to the UK ancestry visa because you are a Commonwealth citizen with a UK-born grandparent. So perhaps if there is a plan to move to the UK and you are not able to establish a British nationality claim, the best alternative would be to look at the ancestral route as the next best option. All right.
Thank you, Michelle.
No worries.
Then we have a question from, well, it's just Matthew Haynes. I was born in Bristol in the UK in 1993. And that is his posted resident in New Zealand.
Yeah, okay. So this we talked about with the first few slides. So birth in the UK after the 1st of January 1983 doesn't give British nationality automatically. So we have to also look at the status of the parents. So Matthew, if either of your parents were British citizens, either by birth or by descent, or if they had been in the UK for some time at that stage and had acquired the status of a permanent resident over here, that's called indefinite leave in the UK, I should say. Or perhaps if one of your parents had the right of abode status, so if they were New Zealanders with UK-born mothers, that would also give you a right to citizenship directly now. And lastly, if either of your parents were European citizens, it's also possible that you could acquire British nationality now, although again, we'd have to look at what they were doing at the time before we could definitely say yes or no on that. So we can't say for certain you're not going to get citizenship effectively just by being born in the UK. It's the status of the parents as well we have to look at. And I hope those four options can give you a bit of a steer as to whether you qualify or not. Excuse me. Okay, John.
Great, thank you. Next question is from Kyle. Kyle was born in New Zealand in 1977. Parents born in New Zealand in 59 and 57. His paternal grandparents were born in the UK.
Okay. So for you, Carl, I mean, obviously there's a route for your father, who if he wants to claim a British passport can, probably from his father's birth in the UK. Obviously, you know, we know that your father would have been a British national by descent and wouldn't sadly be able to pass it a further generation to you. Now, and I also know that he wouldn't be born in the right time for him to be married before 1949 to your mom, nor would he be born at the right time, I believe, for him to be in Crown, for his father's Crown service to matter here, and so on. So I think it's unlikely that you have a claim to British nationality. I do, however, know that it is very likely that you would have a claim to an ancestry visa, as I touched on in my earlier question. So again, if there are plans to move you and the family into the UK, the ancestry visa will probably be what I would go for there. But in terms of British nationality, it doesn't look likely for yourself.
Okay.
John.
Thank you, Michelle.
John, we should just give a few more details about the ancestry visa, I think, because there's so many people here who qualify. So I think it's worth noting that those who apply for the ancestry visa have to show an intention to work in the UK. So it's often thought that those who are effectively in their retirement, or over 65, if you like, in terms of the UK, can't qualify. This is not the case. In fact, if you're economically self-sufficient, and you're able to do any type of work, including voluntary work, or something of a sort of retirement nature, then it's quite possible to apply for the visa. So age is no bar on this one. And in fact, I think the oldest person we've acquired an ancestry visa for was in fact 83 years of age. So there's it's quite a nice status to have, and it'll still lead to the indefinite leave and settlement if you want to move to the UK. Okay, back to
thank you, Phil. Another note is if you have had the ancestry visa before, you can apply again. You can have it multiple times. Moving on to the next question is Colin. Colin was born in Australia in 1976. His parents and their parents were born in Scotland and immigrated to Australia more than 50 years ago. What are his chances?
Well, pretty good, Colin, frankly. The bottom line here is because neither New Zealand or Australia or the UK have any issues with dual nationality, excuse me, there was no need for your parents to ever renounce British nationality to claim Australian or New Zealand citizenship, if indeed they have that. So you should be simply a British citizen by descent, and should be able to apply for a passport directly, assuming your parents were married. If your parents weren't married, you can claim through your mother now in any case, but a specific application, an extra application is needed as an interim. So it's good news for you, Colin. You do qualify either way from either side of the family.
Great. Thank you, Phil.
Okay.
Our next question is from Ian. Ian was born in New Zealand in 1945. His father and mother were born in New Zealand. His maternal grandfather was born in the Cape Colony. I'm just going through.
Sure.
His maternal grandmother was born in Australia in 1886. And then a paternal grandmother born in New Zealand as well.
Okay. Yeah. So I think we have all that information about the paternal grandfather, but I think it will make little difference anyway, so we can just answer the question here. Obviously, a different mix of territories here. Unfortunately for Ian, even though, as Philip touched on earlier in his first couple of slides, there's no doubt Ian would have been a British subject at the time he was born in the sort of pre-1949 period in New Zealand. But not having a father born in a place that remained part of the UK or the UK itself would therefore mean that when Ian became a citizen of New Zealand and then the laws changed in 1949, he would not have picked up the next form of British nationality in that time period, and hence he wouldn't have a claim in the modern day. And in regards to his British subject status, that was probably lost in terms of nationality when he became a citizen of New Zealand itself in this sort of post-49 period. His connection on the mother's side to South Africa would not help either, because South Africa, again, at best it was part of the UK till about 1949, and it also became an independent Commonwealth country on the 1st of January 49 in terms of British nationality purposes. So I think for Ian, unfortunately, there's no way I could see that he would be able to claim British citizenship in the modern day. All right.
Okay. Our next question we'll have is from Marion. Marion was born in New Zealand in 1978. Her father was born in the US in 1938. Her mother was born in New Zealand in 42. Her maternal grandparents were born in the UK, and her paternal grandparents were born in the US.
Okay, Marion. Again, quite a similar situation, what we're seeing a lot of today, but with the influence and the connection to the USA as well. The USA, of course, isn't a great place to be claiming British nationality from. It's an independent territory from much, much earlier than New Zealand itself, so we know that there's no claim that can come down the female side, sorry, the male side of the family. With your mother, we know that she's become what we call a citizen of the UK and colonies in the first generation by descent, because her father was born in the UK. So to claim in the second generation by descent, there's got to be one of those features which allows a double descent claim here. So if your mother was in UK government service at the time you were born, that would be one way. Outside of that, it seems unlikely that a claim could come down, and you're going to be looking at the ancestry visa only. Again, as a solution there. There's no other obvious route there for you for direct citizenship. So we're back to the ancestry visa. I saw another question from a lady called Heather who was asking on the ancestry visa about financial value requirement for the over 65s on the ancestry visa. That touches on what I mentioned about age being no barrier. Heather, that there's, and in fact for everyone's benefit, that there's no specific financial value or requirement that you have to meet in terms of a monetary figure in the bank, which there is for other visa classes for the UK and other countries. So it's not a question of showing that you've got thousands of pounds in the bank, although that would obviously help. What it is a question of is showing that you have the ability to make ends meet and you will be self-supporting. So with the ancestry visa, you're not allowed to claim public funds in the UK, so there's no access to state aid of any sort. And in fact, you have to contribute a fee towards the NHS, which I think is about £3,000 at the moment, so you can get medical treatment whilst you're over here in the UK if you need it. So everyone's circumstances is slightly different. If you have credible offers of support from third parties, so if you're staying with friends and relatives in the UK, then you'll need to show that you've got less money for support than if you were staying at a hotel or a boarding house. And so it's really going to be down to your own personal circumstances as to whether you meet that requirement. But as a rule of thumb, if you can show clearly that you'd have the ability to support yourself for at least 6 months when you get over here, in line with your own personal circumstances, that would work for you. Okay, so Marion, ancestry visa only. Heather, that's just the financial requirement on the ancestry visa itself.
Okay, great, thank you. Moving on to Rachel, born in New Zealand in 1990, father born in the UK, maternal grandparents born in New Zealand, and paternal grandparents born in the UK.
All right. Yeah, I mean that's already looking good for Rachel, even though she's born after 1st of January 1983. Her father was born in the UK, and you know, there are two ways I think it can mainly go. Is if you know her parents were married before she was born, then we know this is more or less a straightforward case for a British passport for Rachel, because she's probably been British since the day she was born. If in the event her parents who aren't married at the time she was born, and perhaps married after her birth, again, it's worth looking into, because sometimes a subsequent marriage does retrospectively legitimize the birth. And if the parents weren't married at all, that's also fine, because as I think Philip touched on earlier, we do have a set of newish regulations, I should say, that allow such a person like that to register as a British citizen in the modern day. So I think for Rachel, either of those three scenarios really probably would be a good route for her to claim a British passport in the modern day, John.
Okay.
Uh,
Rachel has asked a question about
mm,
documents for the UK. You
okay.
can go to the General Registry Office to get, or online to get documents. If not, you can ask
Mm.
one of our consultants on WhatsApp or email. They'll be able to guide you there. Then moving on to Nicole, also born in New Zealand in 1963. Her parents were born in the UK. Mother in 1942, father in 1939.
Yep, again, this looks like a pretty straightforward position of citizenship by descent. In this case, Nicole's born before 1983, so it's a slightly different position to Rachel. So whether if we're looking at the male line, then the claim would have been automatic. Nicole would have been a citizen of the UK and colonies to start off with at birth in the 60s. Then with the changeover in the law of 1983, she would have acquired British citizenship. If the parents weren't married again, the claim still exists through the mother's line with a specific application. So it's good news for you, Nicole. On that, I don't see why you couldn't go ahead with a passport application. So please do get in touch.
Okay. We have a question from John. John says he's retired. He is a common law partner of a Welsh national. He was born in New Zealand in 1946. Both his parents were born in New Zealand. His maternal grandmother was born in New Zealand, and the rest of his grandparents were born in the UK.
Okay. So for John, although he's obviously in relationship with what I probably take as a British citizen there, and then there could be a spousal visa route. But going on to the nationality side of things, we do know again he would have been a British subject, being born in New Zealand, but would have then subsequently lost his British subject status on becoming a citizen of New Zealand there. And that's only because he doesn't have a father born in a place that remained part of the UK from the 1st of January 1949 onwards, or the UK itself indeed. We do have, I believe, what I heard there, which was the rest of his grandparents are born in the UK, so he does have a grandparent born in the UK, which means, again, if he's looking to relocate to the UK and start over here, then I would probably go for the ancestry visa as compared to what he may think is far more straightforward, which is the spouse visa. But that's not entirely correct. And I won't go into too much specifics, but the ancestry visa is just that much more cost effective, and in the long run will probably be far more straightforward for him to come into the UK on. But of course, he can get in touch with us to know more about that.
Thanks, Michelle. John, on our website, on the blog, we do comparisons on the spousal visa versus ancestry. There is information on the differences. You can go and have a look if you like. Our last question we'll take is from Leisha, born in 1972 in New Zealand. Her mother was born in New Zealand in 1953. Her father was born in Scotland in 1950. Her parents were not married. Then she has her maternal grandparents born in New Zealand and Tonga, and her paternal grandparents were born in the UK.
Yeah, okay. Alicia, thanks for attending tonight. This is another situation which is where you wouldn't have originally had a claim to British nationality, in line with what we said, with citizenship only being passed in the male line by descent where the parents were married. Since 2014, it's been possible to lodge a specific application with the Home Office to have that right of citizenship by descent. It's an application that takes place in the UK and has to be done before you can claim the British passport. Other problems sometimes you see with these applications, not so much in New Zealand, is that your father's name may not be listed on your birth certificate. If it isn't, we'd have to look at other evidence to see if we can prove your link to your father instead, which could be through DNA testing and the like. Hopefully your father's name will be on the certificate, and if that your birth was registered within a year, the Home Office should accept that as prima facie evidence of the link. Otherwise, you'll have to look at other things. So just to recap, you will have a claim. You'll have to make a specific application to the Home Office, though, before you can lodge that application for the British passport, and we'd be delighted to assist you with that if you want to get in contact.
Excellent.
Okay.
Thank you very much. Thank you, Michelle. Thank you, Phil. It was very informative and I'm sure helpful to those that we did get to. Those that we didn't get to, please, you can contact us again, phone, email, WhatsApp. You can pose that question to one of our consultants. They will be able to help you. But importantly, we would like you to fill in that online assessment, even if you got an unlikely or an unsure or our question didn't give you a definitive answer. Go do the assessment. I've posted the link again. We can give you our opinion and we can take it from there. Thank you to everybody for joining us for the webinar, and good evening.
Thank you.
Thank you.